Yo Yamamo Aqua Bastrancoso at the POG Media. So messages are free and as a waba Jumedian as well. Subscribe, like Jumedian, share Nema Afafro and so and in can be kindly click on the notification bell no so send a baby any news bianom at platform no so I won't so ubahunu the airco and the air by young fat yen 7 no do and yet the embrewa ya in him say a year former Chief Justice Chief Justice Gertrude Torkorno wasa akwa akopie mu e court na de nti okopie mu e court no nyina na say say mapamome a Mr. Monsan family day embra on the bench of the Supreme Court justices no and as judges no enti sansem we an gu apaswa ye twe ho diary na ene na one astute journalist and sorry one astute lawyer be yayenim lawyer edigi tabaklo obebie insem no mu e chiremu die nti a ye maame anase maame justice Gertrude Torkorno ontimi ensa emba back na insema ekoso nyina no ono no nsusu yemu no allegedly wo ni say maame no de ebe dene say no saa de wo si sikino kra no saa be de na Eduzi Okasaye, and he speaks very intelligently in the kasano or the many examples here they etutuja na oche mu dinti ama no entimi ensanya de emba baka wo chese sansem no de court no wie bi hwe ya na amai de omu abo de ayede atu agu ye beko ni akwa akotie yensema ye bra Eduzi Tamaklo ode de ode tuja yenko ni konkotie
Superintendent Alexander Obing and all these people who came through. Thank you very much. That it just reflects the increasing, following that we have on Saturdays, and
our audience is growing.
I want to thank the many of you, and we sincerely apologize for this breaking transmission. The most important thing is that we're back. And
let me just do a quick one.
Yes.
So the point I was making is that if you look at Article 128 of the Constitution, 128 says that the composition of the Supreme Court shall the Chief Justice and 9 other justices. So first of all, she is first seen as a judge of the Supreme Court, then a Chief Justice. So it is one and the same. It is just the performance. So when it comes to the Chief Justice, she has an elevated administrative role added to. And so if you look in the Addo decision, my Lord Justice Databa then took the view that in reading 146, what you see is, it says, like you just showed, 1462.
Let's put that 146.
It says that a superior court judge and the chair of the regional tribunal may be removed in accordance with the procedure specified in this article. And the procedure includes a determination, a prima facie, and all of those things. You understand?
A different composition of a
Please hold on. Please calm down, step by step. So whereas 146, 1 and 2 says that unless in accordance with the procedure specified, that procedure includes the prima facie determination. However, when it comes to Chief Justice, it jumps and does not make any reference to prima facie determination. So when it got there, Justice Databa then says no. Even though there's no specific reference of the word prima facie relative to that of the Chief Justice, because she is first a judge of the Superior Court before a Chief Justice, that process should apply. And that is how that mischief was cured in the Franka-Jechum decision.
Right.
It's instructive to note that if you read further the Franka-Jechum decision.
So that position cannot be described as an arbiter?
No. It was a main argument. And now I want to go back to the legal submission my senior Nana Santi Bedietu made in the Addo decision. Because you will notice that in Ajechum, the argument Ajechum canvass were agreed. It's what the Supreme Court finally brought finality to. Now, I want to read the argument that was made by the lawyer, Nana Santi-Bedietu. It reads in paragraph, it starts from paragraph 10. It said, because the Chief Justice is a judge and the chairman of the regional tribunal, the Constitution in its wisdom provides that the Chief Justice can only be removed from office on the same grounds as that of any other judge or the chairman of the regional tribunal, and it reads, quote, stated misbehavior, incompetence, grounds of inability. Now, 11, this is the argument. Thus, the Constitution makers by the expression shall not be removed from office except prohibits the removal of a justice of the Superior Court or regional tribunal from office on any ground other than the one stated in Article 146. A Chief Justice, now this is instructive, a Chief Justice being a justice of the Superior Court can only be removed from office on the ground set up in Article 1461 and no other ground.
And what are the grounds?
Now listen. So I'm coming. 146 deals with 1461 deals with stated misbehavior, incompetence, inability. And in the case of Torkorno, she was removed on stated misbehavior. The argument on incompetence was rejected by the committee. Now, most importantly, 12. These are the arguments being put before the Supreme Court by Bedietu. The Constitution does not provide any separate and distinct grounds other than those set out in Article 1461 for removing the Chief Justice, qua Chief Justice, from office. Thus, under the Constitution, a Chief Justice cannot be removed as a justice from office and remain on the bench as a justice of the Superior Court. He can rather be removed from office on the same ground as justice of the Superior Court. Now listen to Justice Modibo Okran. In response to this beautiful argument by Bedietu, he says, personally, I do not agree with you. It's unfortunate, but that is the law. And so,
that's what Professor Justice
Modibo Okran, may his soul rest in peace. In his reasoning,
so that's what you see there. He said, as unfortunate as the consequences will be for our hypothetical judicial brain, 10 disastrous administrator, I would have to agree with the plaintiff's position, but that also
and the plaintiff position was canvassed by the lawyer Nana Santi-Bedietu.
He continues. That also makes me wary of any interpretation of Article 1466 that will make it so easy to remove the Chief Justice.
And so, you see, even at that time, there was some apprehension by the judges that it would be so easy to remove a Chief Justice.
Yes.
But the court said, look, this is what the plaintiff is saying. Yes. Regardless of our emotional attachment with whatever or sentiments, we believe this is the law.
What the plaintiff is saying is the law.
Yes, what the plaintiff is saying is the law.
The law is the law.
And agreed. So it cannot be suggested, even remotely on this platform, that was an obiter.
But I think
extremely. In fact, it would be completely disingenuous to do that. What is even instructive is the idea here that the view of Nana Asante Krobia, SKB, who was only a member of the Committee of Experts. The Committee of Experts did not write the Constitution. In fact, most of their proposals were rejected.
You're making a different argument, please.
No. What I'm saying is that
evidence to the committee. I'm not talking about his.
No, I agree. But what I'm even saying now, even at that time.
No, this is about his testimony to this.
Yeah, you are not getting my point. I'm saying that, you see, even what he's saying now was rejected. It is not sacrosanct. Yes. So the whole idea that the views expressed by way of his testimony carries more strength than. But you see, my Lord Justice Amadou Tanko, in the injunction application by Her Ladyship the Chief Justice, address this issue of prima facie determination and the absence of reasoning. Yes, in the injunction matter. You see, people are confusing two issues. There were different matters that came before the Supreme Court. There was one that she herself found.
Yes.
There was one by the civil society group, Sages or something.
Yes, and then there is
Vincent
exactly. So
that's the Civil Center for Elections or Censure.
Yes.
Censure. Now, you see, if you come to Justice Amadou Tanko's reasoning on the issue of whether or not the prima facie should be embedded. This is what he said, and I just want to read that portion. That's paragraph 43. He said, the next ground on which the applicant invites the court to restrain the committee is that the prima facie determination was not judicious, as it was rendered without reasons. I have cautioned myself against prejudicing the substantive relief sought in this action. However, it is not in doubt the applicant herself has acknowledged the existence of a prima facie determined, however described. Whether the form or contents of that prima facie determination rendered it nullity due to the allegation of absence of reasoning is a matter to be determined at the substantive hearing. Be that as it may, I am not oblivious of the jurisprudence from the court that a judgment rendered without reason is by all means a judgment. And then proceeded. Whilst it is the interest of justice that reasons accompany judicial or quasi-judicial outcome, there is no known jurisprudence in our court to the effect that a decision rendered without detailed reason is thereby a nullity. This holds especially true when the prima facie is said to have been made without reason, but which may merely requires adversary to present a defense. And in this case, she appeared before the committee and defended herself. In the relief that she is seeking by way of judicial relief, nowhere does she challenge the prima facie determination. She had moved on from that argument. Her argument now has to do with the fact that she detaches herself, the office of Chief Justice and that of a Justice of the Superior Court. And now says that to the extent that she had been removed as a Chief Justice, she remains as a Justice of the Superior Court. That is what you see in her relief. That is what you see in her relief, without more. So let it not be stated that A, B, C, D, because of that you cannot. My learned senior Kofi Bentele, making his submission, said, look, the matters raised in the petition are matters that were dealt with by the Auditor General, and for that matter, quote unquote, the committee cannot make a determination into it. More or less, they have become fontus with no power, more or less, to like a judicial review of the Auditor General's report, more or less. Please, I want to use one example. If you look at the Public Procurement Act, Senior, you will notice that Sections 1991 provides what you do when the allegation of breaches of the Procurement Act. You remember? It says that a committee, an investigative team shall be put together, investigate everything, and once the investigative team, the authority can recommend ratification. It can recommend rectification. It can actually recommend any of those. So I remember when the issue of Charlotte Osei came up, the argument some of us raised was that since the allegations do not deal with her work as electoral commissioner, electoral or the chairperson, and deals with borderline action, procurement, we should permit her to stay. Because then her function as a chairperson of the commission has not in any way been violated. The argument that the resistance at that point was the fact that no, the procurement issues are antecedents. They come together with the office. And so if there's any allegation of breaches of same or violation of same, that constitutes stated misbehavior. I was in court the day Malik Kweku Baku and Samson Ladi, obviously being led by Samson Ladi Ayenene, came to court. What was their relief? One, that to the extent that the grounds of ABCD, they do not touch to the core function of the commissioner or chairperson. Two, that the absence of a CI to regulate the work of the committee renders the committee's work effectively a nullity. Two issues effectively. When it came up, the Attorney General then, the Deputy AG, Mr. Godfrey Diebu Adame, represented the AG in court that day. And Samson, Mr. Kweku Baku. The court raised the issue of jurisdiction and asked, these matters in your relief, to what extent do they deal with constitutional interpretation under Article 2 of the Constitution? They asked lawyers to address them. I remember vividly the words of my Lord Justice Nene Amegache to Samson. He asked him, counsel, are you saying a public officer who has violated the Procurement Act is not a stated misbehavior? In open court. And that is how the court ended up throwing.
What did the procurement authority say?
Please. Okay. At that time, there was no investigation. So our argument was that since the statute had provided a remedy, that remedy ought to have been followed first, concluded on the matter, and advised that this one you can't even do ratification. On that grounds, you can proceed to remove her. And so the petition to President Akuffo was premature. That was the argument. The court asked something. I remember vividly. My Lord Justice Nene Amegache. He asked him, what sayest thou? And that is how the court ended up dismissing, throwing away the suit Mr. Kweku Baku brought to challenge the removal. It has also been suggested, and I'll maybe conclude on this, that absence a CI pursuant to Article 296 renders everything a nullity. That argument has been made. You see, thankfully, again, nothing new under the sun. When President Mahama pardoned the Muntie 3, my senior Elikplim Agbamava and senior Tuayebua issued separate rates at the Supreme Court. The Supreme Court consolidated it. My Lord Justice Bene rendered the judgment of the court. In one of the relief, they said, because Article 72 raises the issue the president may pardon, what it means is that it brings into sharp focus Article 296C. And since the president is not a judge, he ought to publish a CI to regulate. The same argument that has been made, that in making the prima facie determination, the president and the council of state, they not being judges, ought to have a CI to regulate. Two, that the president may suspend pending the determination, the president exercises discretion, and so there ought to be a CI. This is how the Supreme Court resolved that matter in the Elikplim Agbamava and Attorney General. My Lord Justice Bennett then said, he said, when the decision maker is taking a decision in accordance with, in consultation with, there is no further requirement for a CI. And that the reason for that CI, pursuant to Article 296, is to cure the issue of arbitrariness and to ensure fairness. And so to the extent that in the Muntie 3, the decision to pardon is a decision flowing from consultation with the Council of State, the argument, be it colorful, attractive, that there ought to be a CI, is without merit. And that is how that decision was rendered.
In fact, because
I find it extremely curious. Any argument founded on the ground that one, there was no SCI, so she couldn't have been.
GBA has
So I am dovetailing that conversation into it. Look, the Ghana Bar Association, with respect, the creme de la.
You go so I would see in some no na or share in some no the my message more. Subscribe, like it be and share nema afro and so and kindly click on the notification bell no so send a be yeah the any news be no to platform no so I won't so well who the echo any the air by in some no the do now POG Media day yeah the bring your corner kunkuti of me no na bra e the G tamaklo it was in some no so.
Chief Justice is unprecedented. All such applications for clarity in the position of Kofi Bento must be encouraged so that there's a finality on the matter. Because in his position, all references to pronouncements of this particular relief that the Chief Justice is seeking, or the move Chief Justice is seeking, are arbitrary, to say the least. Does not necessarily create solid precedents to raise questions about the reliefs that she's seeking in her application. Why do you hold a different view?
Okay, so once again, I think that we are just going in circle. The Chief Justice herself now removed, appreciates what the law is. At this point, all that she's engaged in is what the lawyers would call forum shopping.
Why do you describe that forum shopping?
Look, every aspect of this matter, she's gotten one way or the other a court to pronounce on it. It is her dissatisfaction with the judicial pronouncement that she's running around with. First of all, and I've always maintained, there's nothing new under this sun. My senior Bento talks about obiter. I don't know exactly what he's referring to. Frank Ajechum's decision is extremely comprehensive. If you look at the law report itself, it has the more detailed portion of it than what we have in soft. This is what, may he so rest in peace, Justice Modibo Okran had to say in the Frank Ajechum decision. In concurring.
I think we have that. We'll put that on the screen right now.
He says, quote, with no such gap filling, one is left with only Article 1461. And since the removal of the Chief Justice of Ghana from office is pegged to the same set of grounds as any other Supreme Court judge, the Chief Justice, upon removal, will, by implication, also lose his position as a judge. As unfortunate as the consequence will be for our hypothetical judicial brain turned disastrous administrator, I would have to agree with the plaintiff's position. That's not an obiter. That's ratio. But that also makes me wary of any interpretation of Article 1466 that will make it easier to remove the Chief Justice on courts. So that is clear without ambiguity.
And do you have the plaintiff's position to read?
No, I'm coming. I'll come.
Just read what the plaintiff said.
No, hold on. Wait. Because do you know why? At that time, Bratakwete wanted Chief Justice Akwa removed.
Yeah.
And that is what caused, what shall I say, Frank Ajechum to intervene at the Supreme Court. Not only did he want him removed as the Chief Justice, he also wanted him removed as a Justice of the Superior Court. Do you know why? Because the Supreme Court, in reading Article 1281, What does it say? Let me just read Article 1281. And it brings everything into proper perspective. It says, quote, the Supreme Court shall consist of the Chief Justice and not less than 9 other justices of the Supreme. So she is first and foremost a justice of the Supreme Court and a Chief Justice. It is not all. It's not disjoint. So that you will say that she is a Chief Justice, Chief Justice. No. She is first a justice of, and so if you read Article 128, you can put it out there. Article 1281. It says, quote, the Supreme Court shall consist of the Chief Justice and not less than 9 other. 9 other. Because what it means is that she has the same characteristic as the other 9 judges. That's what it is. And so once you are removed, your umbilical cord, the cord, is completely taken, detached.
But if that's the case, why does the Constitution specifically state the process for the
I'm coming there. I'm coming there.
You should have read this one.
Please.
It says may only be removed.
Please,
no.
Please,
when you
please.
read it,
senior.
this is the Constitution.
Wait.
1462. It says
First of all, nobody reads constitutional text in isolation.
No, but that not be removed from office except on shall not be.
So
wait. You
1462.
see when you were submitting, when you were submitting for good reasons,
it should be done as a whole.
So I'm coming there.
Without this,
so I'm coming there.
Hold on.
I'm coming there.
1462.
In Frank Ajay-Chum, the court, hold on.
Very strong.
The
We'll
court,
reference 1462.
Yes.
This is what hold on.
the Ajay-Chum decision was not a cavalier decision. The court construed other constitutional provisions, and in a very interesting manner, even imported provisions just to make meaning of the Constitution. Why? The issue of prima facie was never an attachment relative to that of a Chief Justice. Yes. My Lord Justice Databa then said, quote, because she is also a Supreme Court judge, if in the case of a Supreme Court judge, you are making a prima facie, then attach the same thing to her. Is it not in the reasoning?
And go through the process.
So how suddenly you are creating a constitutional dissonance?
And go through the process.
You don't do that in doing
no
interpretation.
Okay, hold on.
Please hold on.
Why the reference to 1462?
May not.
A justice of the Superior Court of Judicature. Please hold on.
Yes.
Or a chairman of the regional tribunal may only be removed in accordance with the procedure specified in this article.
It is there. And
it is the reference.
Why are you doing this?
Hold on.
Senior.
Hold on.
First of all, you see, even this one came by under the attack. So if you read this provision, the Supreme Court's attention was drawn to this provision. And my Lord Databa said, listen, this one says that a justice of the Superior Court of Judicature, like any ordinary Supreme Court judge, High Court, Court of Appeal, should be removed by the procedure specified here.
Yes.
And this procedure includes the determination, prima facie determination. Then Databa said, look, when it comes to the Chief Justice, you don't find that expression relative to the Chief Justice.
Okay.
That is what got Databa to say. That to the extent that...
Gentlemen, please.
Yes.
We have a
Ajebo enya babedru ha ene di nsem no ebesi e de ma mesre mo subscribe like dwumadi ne share ne ma afoforo enso ensa nka nsem no bisa ne be ya ye de ene news bia no eto platform no so awon so wahunu de eko ene de eba POG Media de ye ne mo ntene de bia no ye di eta so de na yemfa ye Ghana ho nsempa ene Ghana ho da ubo enye de embrem makram